Good evening, everyone. Hope everybody, first and foremost, is safe and well. My name's Charles. I'm a Senior Group Relationship Manager at the Greater Birmingham Chambers of Commerce. And I'm here today with an esteemed panel of guests for our latest webinar, which is all around business interruption insurance during the COVID crisis. So again, I'm sure many of us will agree that this is a kind of critical area as the crisis continues and the pandemic continues to bite, and the lockdown continues. Cash flow really is an important part of that. And whilst the government measures are unprecedented and there's lots of support out there, and as a chamber we've been digesting and providing resource and guidance on all of the government measures that are out there. So I would urge you to continue to review the chamber resources in those areas. But whilst the lockdown continues, as I say, cash flow continues to be in focus. And in addition to the government measures, another area that's coming into focus is business interruption insurance, which is why I'm joined today by my two guests, Neil and Chris. Chris joins us from RLK Solicitors as an associate, and Neil is a barrister at 3PB. And what we're going to do is kind of go through this area and look at how we can provide some guidance and support for businesses currently looking at this. Just in terms of where we are, obviously, I'm sure many of us will look to next Monday, the 22nd, with great anticipation to see what the government decides to do in terms of relaxing measures. In the meantime, please do keep abreast with everything from the chamber. We've got our daily news, so if you haven't signed up to that, please do make sure you're receiving our communications. It'll be our quarterly business report survey shortly as well. So we've just launched the latest survey. So what I might do afterwards as well is make sure that post-event you receive an email including the link to complete that as well, because we welcome everybody's input so that we can get a real kind of pulse check on the local economy and see what kind of businesses are thinking and feeling at the moment. And we use that, going forward as a real measure for our lobbying activities and for our feeding into local and national government. So please do look out for the quarterly business report survey. And also a number of events that like this are continuing to take place. Lots of networking events. And also next week marks the start of our Commonwealth Business Week. So internationally focused from the 22nd of February, we start with an event on the Commonwealth Games. So a Commonwealth Games Business Opportunities Update event next Monday. And that week culminates on the Thursday with our Commonwealth Trade Conference. So again, if you're interested, please do join us for that. But one final thing to mention as well is Chris has kindly mentioned that if you do have a policy that you want briefly reviewed, and then RLK are offering a complimentary review of policies. So I think is there a web address for that, Chris, before we get started?
There is, and I believe the events team in the background will put a link there, but it's BII claims for business interruption insurance, BIIclaims.com.
Brilliant, thanks, Chris.
Sorry, .co.uk. I apologise, .co.uk.
Brilliant. Well, we'll get that shared in the chat as well. Before we get started, final point from me, just to say, if you do have any questions or queries, which I'm sure there will be lots of questions and queries on this area at the end, please do post those in the chat, and I will pick those up and pose those to Chris and Neil at the end. But without further ado, let me hand over to our first guest. So Chris, over to you.
Many thanks, Charles. Thank you. Chris Guy, solicitor from RLK Solicitors, and just a stone's throw away from the Chamber of Commerce. We're based in Edgbaston, Birmingham, a niche commercial litigation outfit. We specialise in insurance law. I've specialised in insurance law throughout my career. But from what was a small niche firm in Edgbaston, we've not overnight, but over many months since the first lockdown, we've turned into the UK's leading law firm in regards to business interruption insurance. And we work very, very closely with another Birmingham business here, the Three Paper Buildings. And I'm joined by Neil Fawcett, a barrister and part-time judge at Three Paper Buildings, somebody who I've worked with for many months now. It's coming on for nearly a year in regards to business interruption insurance, and we really are making a difference for local businesses, but for businesses within the UK, so nationwide. We have hundreds of clients. At last count, I think we're over 700 clients that we're fighting for. We've settled cases, we are settling cases, but it is not without a fight, I'm afraid. There's probably many people in the audience that have tried to make a claim and they've been denied that by their insurance company. And in many, many cases, that's what we consider as unreasonable and wrong by the insurance company. In fact, some of the cases that we've settled, it was initially denied, and it's through pressure that we've applied that they've had the payout that they deserve. I'll touch upon a bit more about that in a bit, but just as a brief overview, this all started because we were worried ourselves about what the pandemic was going to bring. So before the lockdown and before COVID-19 was declared a notifiable disease, we have multiple offices, so have multiple insurance policies with different insurance companies. So we ourselves attempted to put the insurer on notice that we were going to make a claim, and we were denied. But at that point, COVID-19 was not declared a notifiable disease, which you may have seen within your insurance policies is one of the criterias for some insurance policies. So I bode my time, and it wasn't long, it was a few weeks later that COVID-19 was declared a notifiable disease in legislation. So went back to the insurance company again denied, and I thought something isn't quite right here. So reached out to my existing clients, and they were going through the same problems. And we were having that fight for them as well. And before we know it, we are, like I say, the UK's leading firm for business interruption insurance claims. So, like Charles says, we're local, but we are willing for the members of the Greater Birmingham Chamber of Commerce to have a look at your policies free of charge and on a no obligation basis. I'm sure if we consider that you have a case, we act on a no win, no fee basis as one of our funding options for you. I'm sure that we will be able to assist you. It's probably, I think I saw Grace put it into the chat earlier, it's biiclaims.co.uk. We started this back in March. We were one of the first firms out of the blocks to start dealing with this. But you all may recall that the Financial Conduct Authority, the FCA, who regulate the insurance companies, in the summer came out of the woodwork and also wanted to fight for the policyholders like we did. And it was a remarkable event, but to go from nothing to the High Court, leapfrog the Court of Appeal and get to the Supreme Court within circa 6 months is unprecedented. So you may have heard of the High Court judgment and the Supreme Court judgment, which I'll ask Neil to just kindly summarise in a second for you, but not bore you too much with the legal jargon. We want to make this as practical for you guys as possible. Really has assisted in somewhat, but the insurance companies are still having such a fight over this. The FCA only, unfortunately, decided to take a small fraction of policies to bring to court and have judgment on that. And the FCA say it affects 370,000 businesses. Well, we know there are far more businesses than that in the UK. So really, it's a fraction. Now, we have many clients, hundreds of clients with those policies that are affected. But still, even after the High Court judgment, the Supreme Court judgment, the insurers are still shirking their responsibilities. And on cases where they should be admitting liability, they're not. They're reserving their rights, which is just outrageous. And where they have admitted liability, or where they haven't admitted liability, and it's on a without prejudice basis, the quantum offers that they are making are minuscule compared to the true loss that the client has suffered and the policyholder has suffered and what they truly deserve under the policy. So there's a big fight to be had in the payout. Unfortunately, the insurance companies are putting up a real hard fight. And the only tactic I can see really that they're trying to achieve, which we won't allow, is to run the companies to the wall. If the company enters into an insolvency regime, then under the policy, there is no claim. And that's the only tactic I can see them trying to pull, and that's something that we won't stand for and will fight. I can touch upon a bit of that a bit later, but I think if it's okay, I'll hand over to Neil, as a barrister who's worked extensively with me and the team on these cases to explain a bit about the FCA's judgment, if that's okay, Neil.
Thanks, Chris. The FCA judgment was, as Chris said, actually something that took place really quickly in legal terms over the course of only 6 months or so. The first FCA judgment was based on essentially the FCA bringing a test case under the test case framework, which is a relatively recent thing under the civil procedure rules that allows certain parties to get clarity on points of law that might have wide-ranging effect. The FCA in that case basically said that they wanted to look at certain specimen policies. So they took all of the policies that all of the main insurers had for business interruption and split them up into categories and asked the court to clarify what the interpretation was of certain clauses and types of clause. And overall, actually, it was a huge victory for businesses, and it made things far easier for businesses to bring claims based on things like lists of diseases, based on alleged outbreaks at premises, and alleged outbreaks within a certain radius of premises, which was actually one of the big arguments that insurers were having, which they've now had to abandon, because they were previously saying that, for example, if there was a provision in your policy that said that there was an outbreak that would provide cover within 25 miles of your premises, the insurers were actually saying, on the one hand, that if the disease took place nationally inside that radius, and also therefore because it's national outside that radius, you weren't covered. And in fact, the policy only responded if you were if you had an outbreak within that radius and not outside it, which was a rather unfair argument, certainly we thought, and court agreed, in relation to business interruption. And actually they ran exactly the opposite argument, depending on the sorts of businesses and the policy wordings that were claimed. So the court basically clarified that essentially an outbreak anywhere in England and Wales constitutes the term vicinity for certain policies. They also clarified that if there's an outbreak within that radius of 25 miles of your premises and also outside that radius, you're still covered. They gave guidance on things like what it means to manifest COVID, because obviously, if you remember, back in April of last year, there was a complete unavailability of testing. So how you actually prove that you've suffered loss caused by COVID-19 is actually quite an important question. And the court clarified that you don't need a positive COVID test result. All you need is somebody either showing that they've got symptoms of a disease, or if you haven't actually got a witness themselves who can give evidence saying, well, I had a persistent cough and a temperature, you can actually prove manifestation of COVID within that radius or even at your premises by using statistical evidence like data from the ONS or data from the NHS, or even actuarial data to show that it's likely that COVID manifested at your premises. And obviously, if you're a sort of public facing sort of business where you have like a hotel or a pub or something like that, or any other business where you've got lots of people coming in every day, it's perfectly valid to sort of argue, well, if we had 50 people coming in on any particular day, based on local statistics, it's likely that at least one of them would have had COVID-19, and of course that ticks the box for your policy. I mean, as you can imagine, the FCA, the insurers weren't particularly happy about the outcome of the FCA test case, and they all appealed straight to the Supreme Court as well, because it was such an important case. It went straight from the High Court, where the first FCA test case was, leapfrogging over the Court of Appeal and went straight to the Supreme Court. And that gave some more clarity, I suppose, to some of the issues that insurers and businesses would be facing. I mean, essentially, the insurers lost in the Supreme Court, and they lost. Actually, you might think, we think, in a slightly spectacular way, because although the Supreme Court basically said that you've still got to prove that there was actually loss caused by instances of COVID, they actually widened the test of what lawyers call causation very significantly. Normally speaking, if you want to prove a loss, you've actually got to prove that a certain thing caused your loss. And the normal test is to say, well, if the loss didn't happen, you wouldn't have suffered the if the cause hadn't happened, you wouldn't have suffered the loss. It's known in law as the but-for test. But for the effect of one thing, something else would not have happened. And the example that the Supreme Court gave was, well, two examples. One, which was a number of people pushing a bus off a cliff, slightly odd examples. And another one was two hunters accidentally shooting the same backpacker. And in the first example, actually, if you apply the usual test on causation, imagine if you've got sort of 13 people pushing the bus off the cliff. If you took away one of those people, does it mean if you took away one of those people, the bus would still fall off the cliff? Does it mean that that one person who was pushing it off the cliff was not responsible for that taking place? Did they cause it or didn't they cause it? And logically, what that means is that actually, if you apply it to each individual person who's pushing the bus, you end up with a situation where logically none of them is responsible if you apply the standard but-for test. And the same with the two hunters shooting the hiker. Again, if you took away one of the hunters, the other one still would have shot the hiker. So therefore, can you say that can you say that that person is not responsible? Well, in reality, they're both responsible, even if you could take one away and the other one could still have shot the backpacker. So they essentially said, well, look, we need a better test here, and the test is essentially that your particular outbreak of COVID in your area or your particular employee, along with all of the other employees in the country, are what caused it. So, I mean, in reality, post the Supreme Court judgment, we shouldn't really have any kind of serious problems, I don't think, with actually proving that COVID caused the loss. I think what it will come down to in practical terms is basically what the wording of your policy is, and whether your policy, for example, limits the scope of cover to certain specific diseases or in other ways. And just, I mean, I was doing a case last week, which was based on these disease clauses, and you might have seen a fair few of them. They're basically clauses that say that we only cover the following specified diseases, and they list various things such as acute encephalitis, plague, meningitis, smallpox, and all sorts. And the question is, well, are you covered or not? And on the face of it, rather, it looks fairly obvious. COVID's not on the list. Now, the point that we were arguing last week was essentially that is it is included within certain diseases like plague and like encephalitis, which has a very broad definition, and also that the list is actually quite it's not a closed list. Actually, it's sort of an indication type list, more like guidelines. So we're still waiting for the outcome of that case, and actually, if that goes in our favour, we'll no doubt have a huge sort of stick with which to beat the insurers, pursue these claims, and it should be something to help us significantly. So we'll look out for that and see how it goes. But
it's a really, really important case that is, Neil. Thank you for sharing, and that's that Neil's directly involved with. There are lots of policies out there, like I say, that the FCA test case didn't touch upon. And this list of diseases, which are the majority notifiable diseases, which COVID-19 is popular. There's lots of them, and I suspect there's lots of people out there that have been told no by their insurer, by their broker, by the financial ombudsman service, etc., etc. But we consider there's still a fight to be had with those, as we're having in court, like Neil mentioned. So what I recommend is, even if you've been told no by your insurer, to send over your policy. Let's have a look and see if it's a runner. Like there are lots of people that we turn away. Unfortunately, they have business interruption insurance, but it doesn't cover for any sort of disease or pandemic or a non-damage denial of access. Unfortunately, and unfortunately, those are no-goers. But there are more test cases as we speak to resolve the full policy wording that's out there that should cover people for business interruption as a result of COVID. At last count, I think I had about 60 different insurance companies, and each insurance company has a different type of wording, the insurance contract, the policy wording. On average, there's probably about 10 different variants for each insurance company. So you can see how wide this is. But it's on a case-by-case basis, and happy to have a look at those, or if there's any questions from the audience about their particular policy, I can try and answer them, albeit it's without review of your policy. I'd strongly recommend that is sent through. Since the Supreme Court judgment on the 15th of January, yesterday there was a declarations order, which is a draft. It's in draft format. And what that means is the 114-page Supreme Court judgment is being whittled down into a few pages. I mean, at last count, I think it was 26 pages, but at least it's better than 114 of very complicated legal arguments. And it's just what it means for the policyholder, for you. It doesn't deal with what you're due, the amount of money. The FCA test case never brought that. That's done on a case-by-case basis. It's more about legal liability and causation, like Neil has touched upon. But they're still fighting the FCA against the, I think from the top of my memory now, it's about 7 insurance companies at last count. They're still fighting about the contents of that judgment. What the insurance companies are trying to do is water down the judgment so it's better in their favour, as you expect they would do. So there's still arguments going off even after the judgment. This is probably going to go to another hearing, a declarations hearing, where the court decides where in the line it's going to draw, whether it's in the favour of the FCA, i.e. policyholders, or the insurance companies. What we do know is that the insurance companies are still fighting this tooth and nail, even where it is a slam dunk, where the Supreme Court judgment definitely affects those policies. And we're seeing that, like I say, only a few are admitting liability. Others are saying we reserve our rights, and they're really, really pushing hard on offers. On some of them, they're not even making an offer, which is horrendous. Other than that, that's about where we're at. It's all about driving the force with numbers. We're pushing the insurance companies hard, and the results are being seen. We're getting settlements. We are settling cases. We are receiving settlement offers, and hopefully we can do the same for members of the Greater Birmingham Chamber of Commerce. Unless there's anything else from you, Neil, I was going to try and take some Q&As next, and that will probably lead us on to other points that we've not necessarily touched upon. If I have a look in the Q&A, there aren't any in the Q&A section, but
thanks, Chris. I've just
thanks, Charles.
No, thanks, Chris. I've just found there's one in the chat that we'll come to. Okay. So I'll just pick that one up now. But let me say, thanks so much for doing this, and really detailed insight there. And I think, really kind offer to members to have a look at because again, like you say, it's not all black and white. It's always a case of looking at something specifically, particularly in the legal area, because as I say, it's never black and white, is it? In law, there's always an argument to be had. and that's what this is all about. But
there
no,
is.
really signed off.
Unfortunately, there's too many doors being shut as well. We're seeing the same standard, and I can see that the insurance companies have been to lawyers as well, because the wording that they copy and paste is from a lawyer. I can see that a mile off, being one myself. And it's door shut after shut after shut, and clients come to us, and we spot that straight away, and we rehearsed in this now. It's nearly a year since we've been doing this, back in March, April time last year when we first started, and we've learned so much, because of course this until then had never happened before. We'd never had a pandemic like this that would cause business interruption. It's groundbreaking law, and I'm proud to be part of that, to be honest. It's been one of the highlights of my career. Hopefully there'll be further things in my future career which level it, but this has been exciting, but it's also, we've got to remember, we've got to keep businesses going, because this it's great what the government has been doing, and arguably could have done more, but this is going to keep businesses going by making sure that, like you say, the cash flow is flowing.
Great, yeah, no, and that's something that, just to support that, that's something that as a chamber we're behind. We've got our latest Back Our Business campaign out there at the moment, which summarises, in our view, what more can be done to support businesses, looking ahead to the budget, and of course looking ahead to Monday's announcements in terms of where we are with regards to a way out of this and an exit strategy. And hopefully we'll all be sat in a pub, in a beer garden by the summer, and this will be a long distant memory, but for now certainly there's testing times ahead. And as I say, we're grateful that you've taken the time to do this today, and also to review members' policies. But turning to the chat box here, I've got a query from Geraldine, and it's for you, Chris. So Geraldine's asking, does it make sense for a claimant to go through the procedure of notifying their insurance company of a claim, and assuming that's turned down, to go to the next stage of appeal, then assuming no luck with that, going to the ombudsman before getting a solicitor involved? So I think this is more of a kind of procedural thing. Should they be exhausting the other avenues before coming to yourself or a solicitor?
It's a very good point, and thank you for that, Geraldine. There's a principle in insurance that's called late notification of loss, and this will be in every insurance policy. I've reviewed thousands now, and the general principle is that the policyholder, the client, should notify the insurance company of their loss very, very quickly. Depending on the wording, it's immediately, a reasonable amount of time, 28 days, that sort of thing. Now, the issue that we've got is we're nearly a year into this now, not far off. And those policies that were in force at the time may have been renewed since, or they're coming up for expiry. And so if that individual policyholder hasn't notified the insurance company just yet, I strongly recommend that they do before even considering going anywhere else, just to protect their position, because they can, they've missed out on a technicality. It's a hurdle that you don't want to trip over because you were late in notifying them. There is a claims procedure, and ordinarily, if it was, I don't know, a property damage claim, for example, where you can still get by, but you've got a leaking roof and you're putting a bucket underneath it to start off with, to go through the claims process, which ordinarily would be quite straightforward. The issue that we've got with the insurers is that these are just completely unprecedented times. We've got every single business in the UK being affected at exactly the same time, all making a business interruption claim at the same time. Those claims teams within the commercial lines are absolutely stretched. They're outsourcing it to solicitors themselves. They're outsourcing it to. I'm getting emails from loss adjusters and insurance companies from temporary email addresses, temp4 at, temp5 at. The amount of time that they are taking to respond is horrendous. In fact, some of them haven't yet even responded, and we're threatening them with litigation to our letters of claim, which were sent months ago. There are clients that I've seen all sorts of cases now. Like I say, hundreds of clients. I've been reviewed thousands of policies, and there are certain policies that I just know that the insurer is going to say no. And having seen the Financial Ombudsman Service look at that as well, they've said no as well. So your last resort is the solicitor. That I just know that you're just going to be coming back to me in 6 months' time, possibly more. The last I heard, the Financial Ombudsman Service were, I think, a 5-month backlog at least. It's whether businesses can survive that long, without a settlement or a payout or an interim payment. It's a long time, and if they, like I say, if they go into an insolvency regime, the claim's dead. It's within the policy wording. Any form of bankruptcy, CVA, liquidation, administration, etc. The claim's dead, unfortunately. So it's a case-by-case basis and a commercial decision, really, for the client to do what's right for their particular circumstance, really. Neil, anything more to add on that particular point?
No, I mean, I suppose just very briefly that and it probably relates to some of the questions that are popping up in the Q&A box in the chat, but it really just that it is worth fighting these cases and getting a sort of view from Chris about your policy, because actually, as Chris has just said, a lot of the insurers are basically just stonewalling claims, and even if there is a basis for making an argument about the policy, they're just trying to preempt that and saying no right from the off. So just because they've said no shouldn't surprise you too much. In fact, from our perspective, they've nearly all been doing that, and even in cases which are good cases. So just because they're putting you off, don't think that means that you don't have a claim. Absolutely.
I suppose that applies to Julie's question. Our insurers have advised that we cannot claim as we were not subject to a mandatory closure, even though our businesses have suffered considerably since the pandemic started. Is it worth fighting this? Absolutely, Julie. Feel free to send us your policy documents. So it's the schedule and the policy wording. There are two documents that go hand in hand. And ideally, please, you need to send me this specific schedule that was in force at the time when the lockdown, the first lockdown happened, so around the 23rd of March. Send those through, and also the correspondence from the insurance company as well. And on the website, there's a box for you just to give a brief summary about your business. So I probably can work it out from your schedule anyway, but just a bit about who your business is, where it is, and what's happened. Happy to have a look at that for you, no problems at all.
Great, no, that's great. Thank you, Chris. Yeah, thanks for picking up that second query in the chat box from Julie. I can see that there's a couple that have popped up now in the Q&A as well. But what's interesting, I'll come to those next. But certainly, what's interesting from both your responses there, Neil and Chris, is that despite or regardless of what's being said on the one side, or even what you're being told, don't give up. Let's not stop there. This is such a critical time, and as I mentioned in the opening, that's one of the reasons why we're campaigning for more additional support, so that the time that it takes for these to go through and that cash can potentially come through as a result of these policies, in the interim, the businesses may be really struggling, and that's again where we're looking to support to lobby the government to provide additional measures, whether it be the further extension, whether it be altering the CBILS and access to government loan schemes, VAT deferrals, rates bills, all those types of things. It all comes in. It's all really critical at the moment.
Just on that point, Charles, about the government assistance, that's something that the insurance companies, in the cases that we've settled and are settling, they've tried to argue an offset because the client has received some form of assistance from the government, a bounce back loan, a grant, something like that, which is madness. And unfortunately, they continue to argue that. The government assistance in terms of business interruption should be seen as a bonus, really, because it was given to all businesses. There was there was a few qualifying criteria, but one of them wasn't, have you got business interruption insurance? Yes or no? Because if you said yes and they weren't going to give it you, then fair enough. But it was given to everyone. And so we've been arguing it. The Treasury have also sent a stern letter, which I've been privy to the insurance companies via the Association of British Insurers, which says that you can't take that into consideration. So there have been cases which I'm settling as we speak that have quadrupled in value because they were trying to deduct that assistance from the government, and we weren't taking it, and the insurers backed down. So if anyone in the audience has settled the case and that was taken into consideration, then also please get in touch, because there's something that we might be able to do to rectify that settlement. It's a tough hurdle to get over, but happy to have a look at it.
Great. I was thinking of some of those areas actually just now. So you've really opened those up quite nicely in the sense of settlements, and also in the sense of if you've received support, as we were just touching on, from elsewhere, from the government schemes. Does that affect this?
They can't touch that. No.
It kind of brings into question the whole, going back to the kind of PPI days of there was a lot of cases and discussions around there as well. So it just shows that, again, this isn't nothing's, despite what you're told sometimes at school, nothing's final in many cases.
Absolutely. No, it's groundbreaking law. It's the fastest I've ever known something to get to court, to go from a high court to the highest court in the land, the Supreme Court, and leapfrog the Court of Appeal. It's unprecedented. But the traction that we've also got in the background, like the case that Neil's involved in, that we were discussing, and other cases that we've got, it is all on a case-by-case basis. Different insurance company, different policy wording, different type of business that's the client trying to claim. It's unfortunately, it's not a one-size-fits-all.
No, great, thank you. Just a couple of questions that have come in through the Q&A. I've got one here from Fca around business interruption insurance. In March 2020, the broker refused to allow a claim due to the national lockdown. The insurance policy says it mentions illnesses including Legionnaire's disease and matters affecting the business premises.
It sounds like one which to get in touch.
I was just about to say that. It says was adamantly told no, but I'm interested to take your offer of a review of the policy. So we've kind of touched on that. So definitely, please do send that through. And again, Grace, my colleague Grace in our events team, has kindly added that into the chat, I think. So if you're not sure, please do use that address, or reach out to us at the Chamber, and we'll certainly share that as well if you haven't managed to get that down. One anonymous attendee has asked, you've indicated that cover should be in place for any policy with BI cover within the policy. Is that the case? Are there policies where cover may not apply?
No, I didn't indicate that, but there is what I mentioned is there are instances of business interruption insurance that do not cover for these instances. So an example may be that the policyholder took out business interruption insurance, but the policy is very, very narrow, and it will only cover for a narrow set of events. And quite often those events are similar to the property damage section within an insurance policy. So physical damage, things like fire, flood, etc. Unless there's a wide ambit there that would include things like diseases or denial of access due to a non-damage event, then unfortunately there will be no cover. And look, I look at hundreds of policies, thousands of policies, and sometimes it's a 50-50 whether somebody who has business interruption will actually have cover for COVID-19. And Fia has also asked another interesting question here as well. But most interruption insurance policies don't mention epidemics and diseases. How could my insurance policy makes to making a claim? That's exactly the point. Some of them don't mention, well, they're unlikely to mention an epidemic anyway, but they will, if they do, they should mention those diseases, and whether that is a wide ambit of a notifiable disease, which is just a generic sort of infectious or contagious disease, or whether it's, as Neil was discussing, this list. And look, it's difficult to spot these insurance policies are hundreds of pages long, and often these are on page 100 and something, really deep in. So you've really got to have a keen eye. I know them like the back of my hand now. It's quite sad, really. I can tell somebody for a specific insurance policy what page it's on and what paragraph it is. It's quite sad, but that's what I've been doing for the past nearly a year. Look, probably best just send it to the expert, send it to us. We can have a look and give you an indication straight away, more or less, to say whether it's a runner or not.
Great. It certainly sounds like, I mean, I remember doing my law degree at University of Birmingham, and there was the equitable rights, the backup rights that were often there in the early days of the legal system that were used to do the right thing. And it certainly sounds like in some cases this is one of those instances where the courts, the judiciary are looking at it and they're trying to do the right thing.
There's a huge public policy point being fought here, politically as well.
Yeah, no, great. I think that's everything that's come through the chat and the Q&A. It's been really great to do this today, and some really poignant points made, and certainly some interesting clarifications as well there. That again, not everything is final. There could be hope even if you've been turned down on numerous occasions. So. Any final thoughts, both Neil and Chris, if you want to kind of provide a bit of a final summary views?
For me, it's probably touching upon the late notification of loss point again. If you haven't already made a claim, or you made one and were denied it, it's to act quickly. It's not, and because your business is ultimately going to rely upon it as well. So for me, it's acting quickly and putting in that claim if you haven't already done so. How about you, Neil?
I'd just add that a lot of these policies, I mean, the question that Afia had put forward about epidemics and diseases, a lot of the policies don't sort of make specific reference to things like diseases and epidemics. It doesn't necessarily mean that you're not covered, because actually there are some policies which are all risks policies, which are some of the widest ones, where actually you might have the very most easy time making a claim, and potentially a sizable one, where they actually are designed to cover all risks as opposed to only specified diseases or epidemics and things like that. Similarly though, even if policies for example mention certain diseases and not COVID-19, I think there was a question that mentioned Legionnaire's disease. Actually, whilst it might not be Legionnaire's disease, you've got to look very carefully at what the actual wording says. Firstly, as to whether any mention of the disease is an exclusion clause, or whether it's actually a clause that allows you in effectively, or even if the clause doesn't relate to Legionnaire's disease, there's potentially still scope for arguing that it might be something like either encephalitis, or it might be part of the more wide all risks cover. So I mean, at the end of the day, it's a question of what the wording is, and actually even similar policies can have very similar wordings but actually have very different effects. I mean, one from just last week, for example, was the difference between, in these lists of specified diseases, mention of an outbreak of a specified disease as opposed to an occurrence of a specified disease. And actually, if you've got the word outbreak, the word outbreak, of course, denotes that it's potentially infectious and spreads and all that, and it might be slightly more narrow, and the word occurrence is simply that the disease was there and happened. So you get these very slight differences, and also differences in terms of things like the word vicinity. You might actually have two identical policies that use the word outbreak in the vicinity. One policy might actually define the straightforward English word vicinity as being 5 miles, and the other policy might not define vicinity as 5 miles, or indeed anything. It might just use the word. And of course, from the test case, we know that vicinity means anywhere in England and Wales. So you potentially have wordings that are exactly the same, even, but with very different effects. And the only real way that you can get an idea is send it to somebody who's seen so many of them that they probably dream about them. And
no comment.
no comment from Chris, but I suspect he probably does after the number he's seen. And so I that's the way that you really can get the best advice, by actually asking for an expert opinion on it. And second guess it, and don't rely on what the insurers say, because they've been turning down even the very good claims. And as Chris had said, actually in his the case that he was dealing with, I mean, one of the cases similarly that I saw was that initially they reject your claim, you carry on pressing it, and they offer you sort of a small figure, sort of tens of thousands of pounds, and you carry on pressing it, and then it goes up to hundreds of thousands. So don't lose hope, and go to the experts.
Absolutely. I suppose on that epidemics point as well, that is one of the things that the insurers were trying to argue in the FCA test case. Things like pollution exclusion clauses and microorganism contamination exclusion clauses. These small little paragraphs hidden well within hundreds of pages, and saying that what this means is we don't cover for epidemics. Well, we said that they were wrong since the start. The High Court agreed with us, and the Supreme Court agreed with us, so we were right all along, and the insurers were wrong. You can't give with one hand, i.e., we're going to give you disease cover, and then take it away with the other, but we're going to exclude anything to do with contagious pollution, blah, blah, blah. It doesn't make sense, and the Supreme Court and the High Court agree. Another point about that has just escaped my mind, but I was going to mention it. I've just lost my train of thought. But it's Aviva. Aviva Insurance said since SARS, circa 2002, we've never insured for epidemics or pandemics. And they made that statement bold on their website. And so I've got hundreds of cases with Aviva and hundreds of other cases which unfortunately didn't have the right cover. Not in one of those policies does it say we do not cover for epidemics or pandemics. Although they make the statement, there's nothing in the contract to back it up. And hopefully they'll take it down the website.
And exactly along the lines of what Chris is saying, nowhere does it mention that they don't any longer provide cover for SARS, etc., until you look at the new policies.
Exactly. Here's what
when you look at when you look at sort of April, sort of mid-April 2020, you start coming across these clauses where they say we specifically exclude SARS, coronavirus, any mutation of it, anything similar to it, and you're like, well, you didn't include that wording in your previous policies. Maybe there's a reason for that.
And coronavirus has been around since the 1970s. SARS, similar sort of time, I'd have thought. COVID-19, absolutely. But here's what you should have done. We specifically exclude epidemics, pandemics, any variation, mutation, coronaviruses, etc. Unfortunately, they left themselves wide open.
I'm just going to say that there could be some either popular or unpopular policy writers, underwriters out there at the moment. Some of them that were
I suspect, having looked at the insurance policies throughout my career, they're long retired, because it's not often they get that updated, to be honest. So they're probably safe. Yeah,
good. Great. Well, we're just approaching the hour. I think it's a good time to finish. I think many of us will be getting ready for the dinner run. I think the home cook or the takeaway, perhaps something different on a Tuesday.
Pancakes.
And pancakes, of course. Yeah, how could I forget? I think we had ours this morning. That's probably why I've moved on. But look, thanks both. Thanks to Neil. Thanks to Chris. Thanks for taking your time out today to help Chamber members uncover the areas around this and the details around this. As we mentioned, as Chris has mentioned a couple of times, please do follow up and send those policies, wordings, and a little bit about your instance and your circumstances through to that address when you get a chance. And yeah, all that's left for me to say is thanks everyone for tuning in this evening. Thanks again to Chris and Neil for running us through this. And keep safe, everyone. Take care and stay in touch. And have a great evening.
Thank you.
Hope to see you all soon.
Cheers.
See you soon.